Hi everyone. Today's session is the assignment discussion session on level 5 unit equity and trust. So we've done all the learning outcomes, we've done the 5 learning outcomes, and now we're going to go on to doing the assignment discussion session. Before I go on to the assignment discussion session, I want to just give you a summary of what we've done in each learning outcome, and then you've got a better idea of what to do for your assignment discussion. So looking at learning outcome 1, which was to understand historical events leading to the development of and nature of equity. In learning outcome 1, we looked at the key historical elements of the creation of equity and common law. We looked at the significance of the Earl of Oxford's case, so why that case was so important. We looked at the distinction between common law, equity, and statutory rules. We looked at the administrative fusion, the Judicature Act, and the equitable maxim. So we looked at classification of law as well. So the types of law we have in the UK: constitutional law, statutory law, administrative law, civil law, criminal law, procedural law, substantive and business law. We also looked at the elements of public and private law briefly. We looked at what equity means in the term of law and how that is associated to the issue around common law. So we looked at the principle of equity. We looked at what common law was and what common law, what the implication of common law was for equity to be implemented. We went to look at the importance of the law of trust and how it was the most important and enduring creations of the Court of Chancery. We then went on to look at English trust law within learning outcome 1. We looked at 1.1, explain the key historical events to the development of equity, which is part of your assignment as well. So we looked at the historical events, things as we looked at the petitioning of the King, the post of the Chancellor, the Court of Chancery. We also looked at how equity was developed in regards to common law. We went on to look at the historical background before Norman conquest. So we looked at the time period, the medieval England, the 8th to 11th century. We then went on to look at some key dates that were really important in regards to the history around equity and common law. We looked at the importance and significance of the Earl of Oxford case, 1615, in regards to equity and common law. We then went on to look at a really important case in regards to common law, which was the G and Pritchard case. We then went on to look at the fusion of equity and common law, and we referred to the Judicature Acts. This is all within learning outcome 1. We then went on to look at the Supreme Court. We looked at 1.2, which was to examine the relationship between law and equity. And we looked at the meanings of equity, things as like body of law, rules, fairness, value of property, share or participatory interest on an equitable right. We then went on to look at the relationship between common law and equity. We looked at the differences in remedies available. So we looked at common law and equity, the difference between them, the basic difference around that. We looked at the 1.3, which was explain the meaning of equitable maxims. We looked at some of the maxims. There were more on there, but we looked at some, which was equity sees that as done what ought to be done. Equity will not suffer a wrong to be done, wrong to be without a remedy. Equality is equity, and one who seeks equity must do equity. He who comes into equity must come with clean hands, and equity follows the law. So these were some of the maxims we looked at. We also looked at the element of why these maxims are important in regards to common law and equity. And then we went on to look at learning outcome 2, which is to look at understanding the requirements for the creation of a valid trust. So this is learning outcome 2. We looked at what a trust is and what are the different types of trusts. So we've got fixed trust and discretionary trust. We looked at the powers in a trust. So we looked at mere power and ordinary power and what that actually means with regards to a trust. We then went on to look at learning outcome 2, mere power, fiduciary power and non-fiduciary power, and the importance of that, and used case law to amplify that. We then looked at 2.1 to analyse the features of different types of trusts. So we looked at discretionary trusts, we looked at fixed trusts, and we looked at examples with regards to each of these trusts as well, so that it's easy for you to understand what each of these trusts meant. We went on to look at the case of IRC and Broadway Cottages and Swain and Law Society. We looked at 2.2, which we looked at applying statutory rules and their case law interpretations in appropriate scenarios. We look at what statutory rules were and what they mean within English law and how important they are within English law. We then went on to look at the different types of rules. So we had the different types of approaches that were used by courts in regards to common law equity, were things like literal rule, golden rule, and mischief rule. And we went through each of these rules in regards to that. We identified what each of the rules meant, and we went through the elements of how these rules apply in court. And we looked at several types of trust: express trust, implied trust, discretionary, and fixed. We looked at certainty of intention and why that was important in regards to one of the requisites in regards to the use of a trust. We looked at the Regal Bikinian case, 1970. We looked at certainty of subject matter, and we looked at certainty of objects with reference to case law in learning outcome 2. We also looked at 2.3, which was to analyse the impact of illegality on legal presumptions. So we looked at what is illegality of the contract, what it meant. We looked at the example of illegality found in a contract and how that could be things like, employment contracts or issues of hiring underage workers. We looked at the statutory prohibitions of contracts and referred to express prohibitions and implied prohibitions. And we looked at the case of Reem Mahmood and Isfani, 1921. We also looked at the common law prohibition of contracts, which was public policy, and referred to the cases of Bigos and Boosted, 1951, and Beresford and Royal Insurance Company, 1938. We then went on to look at contracts which prevent the administration of justice, and referred to the case of Hyman and Hyman, 1929. We looked at contracts which are sexually immoral, and looked at cases such as Pierce and Brooks, 1865, and Sutton and Michon Rea, 2003. We then went on to look at common law prohibitions of contracts, restraint of trade, and we looked at, is the contract reasonable? We also looked at the effect of illegality and referred to the case of Holman and Johnson, 1775, and we looked at severable illegal contracts, which I looked at Sadler and Imperial Life Insurance Company of Canada. We went on to look at collateral contracts and referred to the cases of Fisher and Bridges, 1854. And we looked at claims based on illegal contract within learning outcome 2. We went on to look at elements of recovery under illegal contracts and how one party is treated unfairly induced into a contract. So things like duress and undue influence, and looked at the case of Hughes and Victoria, Liverpool Victoria Legal Friendly Society, and Tribe and Tribe. We then went on to learning outcome 3 and looked at understanding the concept of the beneficiary principle and exceptions. We looked at the elements of types of express trust, so charitable, private trust, bare trust, fixed trust. We then went on to look at the exceptions to the beneficiary principle. We looked at private express trust and what that meant within a trust or a will. We looked at the beneficiary principle in regards to, we gave an example of a beneficiary principle. We then went on to look at the rationale of the beneficiary principle, why it was adopted. We looked at the case of Barker and Circular Society Limited and Morris and Bishop of Durham. We then went on to look at Incorporated Association case. A really famous case in regards to that is the case of Neville Estates and Madden, 1962. We then went on to look at other case law such as Re Grant and Re Holy Town Football Club. We then went on to look at trusts of imperfect obligation and the importance of that and what they are. We went on to look at trusts relating to tombs and monuments and the importance of that. We then in learning outcome 3 went on to look at what discretionary trust is in more detail, the role of discretionary trust and trustee and the test. We looked at the important case of McPhail and Dalton, 1970, and what that meant in regards to trusts. And we also looked at elements of Clause 9 in regards to trustees and how they apply the income. So that was learning outcome 3. We then went on to learning outcome 4, which is to understand equitable remedies. In this one, we looked at equitable remedies. We looked at equitable remedies such as specific performance, rescission, injunctions, discretionary with reference to cases such as Cody and Rutler, Cooper and Phibbs, and things like Morris and Redland, Briggs and Morris. We then went on to look at the general nature of equitable remedies. And then we went on to look at remedy available only if remedy at law is inadequate, and looked at the case of Wilson and Northampton and Banbury Junction Railway Company. We looked at equitable remedies are always discretionary. We went on to look at equity acts in personam and equitable remedies. And then 4.1, evaluate conditions for tracing in law and equity. We looked at the definition of tracing and why it's so important with regards to the recovery of property, and tracing in common law and tracing in equity. We then went on to look at mixture of trust funds with trustees' funds. 4.2 looked at the application of the change of position of defence. We looked at the Lipkin, Gorman and Carpenter case in regards to that. We looked at another defence of estoppel. We then went on to look at 4.3, which assessed when specific performance is the most important equitable remedy. We looked at equity acts in personam with reference to the Baltimore 1750 case and how the remedy is discretionary. We then went on to look at the Article 2 of the Uniform Commercial Code in United States and what the relevance of that code was in United States. We then went on to look at learning outcome 5, the final learning outcome before we go on to the assignment discussion. We looked at understanding trustees' administrative powers and duties and why they are so important. We gave a summary of equitable remedies again in regards to injunctions, rescission, specific performance, discretionary. We then went on to look at 5.1 and explain the power of advancement and maintenance and how it could be utilised by trustees. We then went on to look at the powers of trustees, what the duties of a trust administrator are, things like overseeing investment, keeping beneficiaries informed, protecting beneficiaries' interests. We then went on to look at 5.2 to differentiate correctly between administrative duties and fiduciary duties. We then looked at fiduciary duties in regards to things in regards to trustees' unpaid office, and we referred to cases in a diagram on Dugan and McPherson, Campbell, Walker, Holden and Holder. We looked at trustee duties and liabilities, so if there was a breach of his or her fiduciary duties. We looked at the fiduciary duties with reference to cases. We looked at the essentially fiduciary, what they must do, how it arises from statute or from common law. We looked at fiduciary nature of certain relationships and referred to cases such as Reading and Attorney General, AG Attorney General for Hong Kong and AG Guardian. We also looked at remuneration. We went on to look at 5.3, which to evaluate trustees' defences for breach of administrative duty. So if there was a breach of duty, who is liable for that breach, and if it would lead to loss of the trust fund. We looked at the defences available exemption clause, so where a trustee could be protected. We then went on to look at limitation and went on to look at latches, consent of beneficiaries. We then went on to look at statutory relief under the Trustee Act 1925, Section 61 of the Trustee Act. We also went on to look at Section 62 of the Trustee Act in regards to where a trustee commits a breach of trust. And that was the final element of learning outcome 5. Now we're going to go on to looking at the assignment discussion, which is here. So firstly, just a little bit background so we finished give you a summary of all the learning outcomes. Now looking at the unit aims and what the element of this is. So in the unit, this unit equips the learner with an in-depth knowledge and understanding of the principles governing the law of equity and trust. So after doing the 5 learning outcomes, you should have an idea of the elements and principles governing the law of equity and trust and why it's so important. So it also enabled students to understand and apply equitable rules to fact-based scenarios. So using case law, we gave you examples, and also using examples, real-life examples, to identify where trust is and what can be a trust. Also to resolve issues that potential clients face and types of equitable interests, equitable trusts and remedies, and we looked at how equity interrelates with other legal topics and how equity principles apply in domestic and commercial context. So here we looked at the element of equity, how it would enable you to understand the laws around equity, what the laws are, things like the Trustee Act, why these laws implement certain principles. We also, so you'd be able to identify the duties of a trustee, fiduciary duties, non-fiduciary duties, things like elements of what they're allowed to do and what happens if a breach occurs within the trustee's duty. We looked at the importance of Section 61 and 62 in regards to breaches. So these are the unit aims of what the learner must know. So just going into the assignment. So at the start of what needs to go on the assignment. So this needs to be included. So at the start, you need to have your name on it, which is really important for the learner because it identifies to the assessor who's done the work. Your registration number, the unit level, so which in this case is level 5, equity and trust. And it's really important, it's quite clear that, they're able to understand that. Again, now, second part of it is the assignment declaration. So you are doing this assignment. You are the one who's completing this assignment. So you need to complete this form to identify that you are the one who has completed the assignment, your learner name, your learner registration number, your study centre name, which is UK Varsity, qualification title, and then unit reference, unit name, title. This is an example for your word count. Here you are declaring and signing that you are submitting this assignment, and that you know that if there's any sort of penalties or any cheating or collusion, you are required to follow OTHM policy, or whichever body is your awarding body, to follow their policy in regards to collusion or plagiarism or alternative. You are making sure that you have referenced your work properly, and you are signing a declaration to say that the work you are submitting is your own work and there has been no forms of collusion, no forms of plagiarism, and you have followed the policy of the awarding body, and that the work that you are submitting, you have referenced and you have acknowledged with sources. So it could be, referencing, in-text referencing, and towards the end as well. So it identifies that you have not been, done any form of collusion or used, which is a big thing at the moment, used AI. People need to stop using AI because it will be flagged up straight away, and that is a form of collusion and cheating. So you are signing a declaration before you are submitting the assignment. So these guidelines need to be followed, and if you do any form of plagiarism, collusion, or any form of cheating, that would be flagged up. So again, just reducing the size a bit. At the start of the assignment, you need a table of contents. You need to identify where you've done your work, what elements of the work is done, and what page that it's on. You need a font size, which is 12. It needs to be 1.5 line spacing. Your page numbers need to be inserted, and that's to make it clear when you've done the table of contents. And it makes the assessor understand what you're doing if you introduce an introduction. If you have an introduction, and a conclusion towards the end. It will help the assessor as well. Make sure you are putting all your assessment criteria, so AC in headings. So if it asks you to do talk about the history of equity in common law, have that as a heading. Make sure you've got that as a heading, and you make sure you have reiterated that, and then write under that, because that'll I'll explain more when we go on. Okay, so table of contents, font size, line spacing, page numbers, declaration as well is really important, and also an introduction. Yeah. Next, you need to, so we'll look at the learning outcomes. Okay, so these are the 5 learning outcomes that we looked at. So I'm just going to reiterate that to you. Okay, firstly, we looked at understanding historical events leading to the development and nature of equity. We looked at number 2, which was to understand the requirements for the creation of valid trusts. And number 3, to understand the concept of beneficiary principle and exceptions. And we looked at number 4, understand equitable remedies. And number 5, understand trustees' administrative powers and duties. Now, when we're looking at these learning outcomes, the learning outcomes will apply to your assignment tasks. So that's why, you need to know what the learning outcomes are, because as we go through, it'll tell you which learning outcome applies to which task. Okay, so you'll be able to understand. So let's go into the first task, which is task 1 of 4. So there are 4 tasks. So here you need to write an essay on the flexible and continually developing nature of equity. Your essay should explain, number 1, so there's 4 parts to task 1 of 4. Part 1 is to explain key historical events leading to the development of equity, and that's AC 1.1. So you need to put that as a heading before you write before you write about the actual part of it. So before you start explaining the historical events leading to the development of equity, you need to have all that as a heading and then write under that. So the next bit which you'll be doing is to examine the relationship between law and equity. So what is the relationship between law and equity? And that needs to be a heading as well. Okay, so you need to have that as a separate heading and you write under that. Then you need to look at the third element, explain the meaning of equitable maxims, AC 1.3. And then what the maxims that we looked at, things like, he who comes to equity comes with clean hands, things like that. So you need to be looking at that in regards to that question. So you need to identify what that question is asking you and what are the elements of that question. Okay, so you need to write that question out and you need to answer that question with reference to the fact that you're looking at that in regards to the equitable maxims. Okay, so you need to make sure that you are answering that question, but you have that as a heading. Okay. The next one is to analyze the features of constructive trusts. So this is the next bit, AC 2.1, and that's in learning outcome 2, okay? And that you will be looking at in regards to identifying the features of constructive trusts, okay? So you need to look at that with reference to examples, and also look at it in regards to what is expected of you in regards to that. So different types of trusts, features of constructive trusts, what they are, what they do, and in regards to that. So there's 4 parts to task 1, okay? You need to make sure that each of these 4 parts has a heading, each has its own heading, and then you write under the heading, okay? Example of question in task 1 of 4. So I've given you an example that you could look at in your own time in regards to answering one of them questions. So the one I looked at was explain the meaning of equitable maxims and where to find this. So it's learning outcome 1. Okay, so here you will look at learning outcome 1 and it slides 23 to 27. So you need to refer to them slides to look at the maxims and get the answers. Okay, so you need to be referring to slide 23 to 27. Okay, and here you need to be looking at things like just the maxims that relate to equity. Okay. So you need to look at the following answers. So these are the maxims and they represent the accumulated insight and wisdom of the courts of equity and often work as a guide. Okay, so you will need to look at some of these maxims which maxims are listed here. Equity sees that as done that what ought to be done. You need to look at equity will not suffer a wrong to be done without a remedy. Equality is equity. One who seeks equity must do equity, and he who comes into equity must come with clean hands, and equity follows the law. So you must write about each one as well. So you need to identify and write about each one, what each one means, and how judges use it if they do use it in regards to it, and what is the importance of each one. So you need to write about that. And this is just an example of the task one that I've taken out a question and done it like that. So you need to make sure when you're talking about that it's the one you're looking at. This is your heading, this is your question there, and you are writing under the question, and this is your answer. So this is just a brief answer of how you would have done it and where you can find it, but you need to answer this in more detail, okay? Then we go on to task 2 of 4. So this is task 2. On finding out he was terminally ill in January 2019, James decided to distribute some of his wealth before his death. James tells his brother Martin that he is giving him the shares that he holds in the Neptune Limited to provide an income for him to set up his own business. Martin resigns from his job to set up the business. On a visit to his nephew Peter, aged 12, James hands over his grandfather's medals, saying that Peter should have them. On leaving, James took the medals from him. James wrote a letter to his niece, Helen, saying that he was giving his late wife's jewellery. Helen never got in touch about collecting the jewellery. James wrote to his sister Gail, telling her that he was transferring his holiday cottage in Scotland to her to hold in trust for James' 16-year-old daughter, Melanie, when she attained the age of 21. He enclosed an executed trust deed transferring the house to Gail. So this is the scenario. James died in 2019 May, having made a will in March 2019 with his niece Helen as the executor. The will left his cottage in Scotland and his late wife's jewellery to Alicia, his new partner. The will also left £25,000 to the Beantown Birdwatching Club, which is an unincorporated non-charitable organised association. The residue of his estate was left half to his son, Harry, and half to his daughter, Melanie, in the trust until she reaches the age of 18, with Harry as the trustee. The Neptune Limited share certificate and a signed transfer document in favour of Martin were found amongst James' belongings on his death, as well as were his medals. Task 2 of 4. So you are required to advise who is entitled to the Neptune Limited shares. You are advised to look at who's entitled to the jewellery and who's entitled to the cottage in Scotland. So taking into account trusts, you need to look in regards to who is entitled to all of them elements of it. So the Neptune Limited shares, the jewellery and the cottage in Scotland, and I'd advise them on this. That's part A. So you will do that as the first part. Secondly, you will look at B, which is to explain the 3 certainties and the differences between a trust and a gift in relation to the medals. So you look at the certainty in regards to certainty of object, certainty of subject matter, them elements in regards to that. C, you need to look at explaining the effects of legacy of the Benton Birdwatching Club and look at the elements of that. And in here, this would be a heading. Again, part B would be a heading and you would write under that. In part D, you need to explain whether there are circumstances in which Melanie could receive money from her trust before attaining the age of 18 and the impact this would have on the trust funds. So you need to look at if Melanie could get the funds before the age of 18. And then you look at part E, which is analyse Harry's duties and responsibilities as a trustee and the potential defences for breach of his duty. And what you need to look at in regards to that is identifying what his duties are and what happens if he breaches them. In your answers, you must analyse the features of different types of trust, which would be 2.1. You must, that would be a heading, and you would look at the features of the trusts. You would then look at applying statutory rules and their case law interpretation in appropriate scenarios, AC 2.2. So this is looking at learning outcome 2. You would then need to look at examining the need for a human beneficiary in express trust, which is AC 3.1, and the importance of that, why there's a need to have a beneficiary principle here. You'd need to look at illustrating, and that would be a heading, and then you would write under each heading, okay? So you need to look at identifying the rationale around that, why there's a need for that. Then you need to look at illustrating established exceptions to the beneficiary principle, 3.2, and why the beneficiary principle is so important. So you need to look at that. So each of these will have a heading. Then you need to look at describing the various methods by which gifts to unincorporated associations may be affected, and that would be AC 3.3. Make sure you are doing all them in headings with the exact wording here, and do not change the wording, because it needs to be the same wording as describe, explain. It needs to be the command words. Then the next bit of it, you are explaining when power of advancement and maintenance can be utilised by trustees, and that's AC 5.1. You need to also look at the next element, which is 5.2, and that's differentiating correctly between administrative duties and fiduciary duties, and that would be looking at learning outcome 5. Then you would looking at, again, evaluating trustees' defences for breach or administrative duties, 5.3, AC 5.3. Each of these, so there's 8 of them, they need to all have their own heading. They need to have the same command words, so each of them is a heading, and then you will write the answer under them headings. So this is task 2. For a merit for task 2, you must also assess the advantage and disadvantage of adherence to strict requirements of constituencies versus the redraws approach, and that would be one of your heading, and it's ACM 2.1. that's the merit ones. And then to do the second bit of the merit is to explain various constructions of the application excuse me to the beneficiary principle, ACM 3.1, and this is to gain a merit. You need to do both them. So to do all the passes, you need to do all the tasks beforehand, and then to gain the merit, you need to gain the merit ones and do the merit ones. Do not miss them out. To gain a distinction and to get a better mark, you could look at discussing the flaws and inconsistencies of judicial reasonings, ACD 2.1. and that would be a heading, and you would write under that, and then evaluate socio and political reasons for the policy choice to adhere to beneficiary principle, ACD 3.1, and then critique the appropriateness of acceptance of limitation of liability clauses, and ACD 5.1. Now, each of these is, if you want to gain the distinction, so you must write the heading and then write under each one. Use the command words again, and for merit, them elements for the distinction, you need to do the merit ones and the distinction ones to gain the distinction. So if you want to gain a merit, you have to do the pass, merit, and distinction ones. Sorry, now if you want to get a pass, you just have to do the pass ones. If you want to get a merit, you have to do the pass and the merit ones. And if you want to get a distinction, you have to do the pass, merit, and distinction ones. So just it identifies them as extension activities. Task example. So I looked at the one where it says outline the features of different types of trusts, AC 2.1. Where to find that? Learning outcome 2, pages, slides 6 to 11, which covers trusts such as fixed and discretionary trusts. So you could have a look at that in regards to that. Task 3 of 4. Here, Casper is a trustee of the Lantry Charitable Trust. In February 2019, he draws £10,000 out of the trust's money in breach of the trust and pays it into his own bank account, in which he already has £10,000 of his own money. A month later, he bought shares for £7,000 using money from his account. A week later, he withdrew £7,000 and bought a car. The next month, he withdraws £5,000, which he gives to his son Ben to use as a deposit on an apartment he's buying. Realizing he's about to be declared bankrupt, Casper transfers the shares to his daughter, Julie. They are now worth £8,000. On the day he is declared bankrupt, Casper writes off his car in an accident. So task 3 of 3, you are required to advise the beneficiaries of the Lantry Charitable Trust on their position. So you need to look at advising them, giving them some legal advice around what they can do. And then secondly, you need to also advise the son and daughter on their gifts made to them. In your answers, so with the advice of the beneficiaries and the advice of the son and daughter, in your answer, you should also analyze the impact of illegality on legal presumption. So that would be AC 2.1. You need to also evaluate with reference to the advice given to Lantry and son and daughter. You need to evaluate the conditions for tracing in law and in equity, and that is looking at learning outcome 4.1, AC 4.1. You need to also, for the pass, is appraise the application of the change of position of dispense, and that's AC 4.2. So that is in regards to the beneficiaries of Lantry Charitable Trust and the son and daughter. For a merit, so if you want to gain a merit for task 3, you need to also look at evaluating the rationale for the fiduciary relationship in equitable tracing, and that's looking at ACM 4.1. So that is the extension activity if you want to gain a merit. Okay, so for this activity, task 3, the only extension activity is a merit, okay? Example of question in task 3 of 4. So this is just an example for you to identify where you could find the elements, okay? So it's just something that you need to do. Task 3, evaluate conditions for tracing in law and equity. So you need to look at what tracing is in law and equity and what is the importance of tracing and why there's a need for tracing, okay? So you will be looking at here at learning outcome 4. You would be looking at slides 9 and up to 16, which covers tracing in law and tracing in equity, and with reference to examples, but also reference to cases as well. So you need to look at that. For example, in regards to tracing in common law, they looked at the important and famous case of MCC Proceeds and Lehman Brothers. And you need to look at the importance of that in regards to common law, and in regards to tracing in equity, they looked at the cases of Boscawen and Badra and what Lord Justice Millett justified in that case. So you need to be able to identify that and look at the elements of that. Also, you need to look at the elements of what tracing is, why it's used in law, and what tracing is in equity and in common law. So pages 9 to 16 of Learning Outcome 4 would cover that. Okay, so make sure, again, I reiterate this, that make sure that when you are doing each of the assessment, the tasks, that each of the elements of the tasks are done in headings. So each one of them is a heading with the command words as they are, and you write under each one. So that's a heading, and that is a heading itself. So you need to write under each command word. And if you want to do the extension activities, you need to look at evaluating the rationale for fiduciary relationship in equitable tracing. So you need to make sure you are making it clear what you've done, and make sure you are referencing your sources using Harvard referencing system. Okay, task 4 of 4. So this is the final task. Aziz works for Mombaps Limited, producing apps for mobile phones. He's on a 3-year contract to develop new apps, which requires him not to work for any other app or software development companies during his contract and for 6 months after the end of his contract. 1 year into his contract, Aziz accepts a job with Comp Software Company, who develop bespoke computer software for businesses. When Aziz leaves, Mombaps MOBAPs find that all the material relating to the app Aziz was developing have disappeared, and they fear that he will finish and sell the app himself. So this is task 4 of 4. In this task, you are required to advise MOBAPs limited on equitable remedies if may have them. In your answer, you need to look at assessing when specific performance or injunction can be granted. And that's looking at AC 4.3. And you look in regards to the specific performance or injunctions in regard to MOBAPs limited. So the task here, example of the task that we use is we looked at assessing the task, the only one task there was the assessing when specific performance or injunction can be granted. And we looked at where to find this task, and we looked at learning outcome 4 of the slides. And we referred to in learning outcome 4, because that's where the slides are to be found, we looked at slides 17 to 23, which looked at specific performance or an injunction and the importance of this in regards to equitable remedies and what the courts do in regards to performing their obligations under the contract. So you need to look at in regards to that specific performance and in regards to that reference of cases and things. Okay, so that's task 4 of 4. So now we've gone through all the tasks, tasks 1, 2, 3, and 4. You need to again make sure you reference your work in text, which we'll go through a little bit later. And also you need to make sure that you are using the command words that are in the tasks that you must do, like advise, explain, describe, and use them as your command words and use them as your headings, and then write under each one. Learners must show knowledge and understanding of the subject area. You must provide references to relevant case law and legislation if necessary and if appropriate in the what you are being asked. Be able to support your answers and show evidence of wider reading appropriately. Make sure you are referencing things. Make sure you are referencing your sources that you're using, and make sure you are explaining things with reference to examples if need be. You need to, again, we're going on about referencing, you need to reference all your 4 tasks. You should use and cite a range of case law, academic and reliable sources, and a comprehensive Harvard-style referencing list must be included at the end of the work. A reference list or a bibliography of what work you've done, and it needs to be used in the Harvard system. Use, there's online sites that would help you reference, cite me, and things like Neil's Toolbox, some examples that you could use. End of the assignment, make sure you do a conclusion. You have a reference list or a bibliography, as I've explained, and make sure everything is in alphabetical order and it's done with using the Harvard referencing system. So if you're using internet sources, make sure you put when it was accessed, as that is a way of doing Harvard referencing. Summary, so make sure, again, you start with an introduction and conclusion, and reiterate that, and a contents page, your details on it as well. Make sure you are using Harvard system for referencing, as this would prevent any sort of issues of plagiarism or collusion or any issues that you've taken chunks of quotes out and just put them in. You need to make sure you are paraphrasing things and make sure that you are referencing things in text, okay? And paraphrase things in your own words. You can refer to online sites and help such as, like I mentioned, Neil's Toolbox or Cite Me. They would help you actually put together a reference that you could put, make sure it's in alphabetical order. If you are using diagrams, please make sure you reference them accordingly. Make sure you have a bibliography reference list and it's in alphabetical order, which I've reiterated earlier. Try to use more examples when explaining certain concepts. For example, when looking at theories or any sort of case law or acts. Make sure you are using the assessment criteria as a heading for each part of the task. For example, if you are looking at task 1 and looking at AC 1.1, each part of the task should be done as a heading and answer done as a heading. As I've explained, each task needs to have a heading and it needs to be explained under that heading because it's so important. And do not change the command words. Leave the command words as they are. So if it's describe, analyze, define, leave them as they are. Do not change them into what you think they should be. You need to be referring to indicative content all the time and checking the word count. Read the tasks, some useful tips. Read the tasks carefully. Focus on details. Command verbs, as we mentioned, it could be explain, define, describe. assess, examine, clarify, compare, contrast, critically evaluate. Harvard referencing. Referencing needs to be Harvard system. So the author, the date, the style, for example, in text, Slack, Johnston, Brandon Jones, 2001, in text. In the reference towards the end, it will become as shown. Word limits, give proper headings and subheadings. As I've said, do not use bullet points. Avoid using that. It's an academic piece of work and it needs to look more presentable, and the structure needs a professional structure. Word limits 3,500 plus 10% leeway. Plagiarism or tolerance similarity must be below 20%. Make sure it's way below 20%, and make sure you're not using things and picking things out of AI, because it will be flagged up straight away. Preliminary, you need to make sure you are not copying and pasting your work, as it is plagiarism and would lead to academic misconduct, as I've mentioned earlier. So, because you are signing a declaration, you are stating that, you know, you are signing this declaration to identify that this work is your work and you've not taken this work from anywhere. If you are taking any quotes or anything else, you need to make sure that you are referencing them using the Harvard system for referencing. You need to make sure you check your grammar and spelling and avoid using American style grammar. Try to use the English grammar, things like organization, you know, take the Z out and put the S in. Refer to ebooks and journals or Moodles for these units. And again, any queries or anything, please refer to email us on learnerwork@ukvarsity.co.uk. Submission of the assignment. Now we've done the 5 learning outcomes. The submission is 2 weeks of completion of the unit and its delivery. So as the unit on equity and trust has been completed, you are now able to get on with the assignment. And if you have any issues around that, or if you have any issues of submitting in 2 weeks of completion of the unit, then you need to contact learnerwork@ukvarsity.co.uk. Any queries need to go to that email address. What I'm going to do now is I'm going to stop sharing the assignment discussion, and these are available on Moodle for you. I'm just going to share the assignment brief with you so you have a little bit of an understanding of what the assignment brief is. Okay. That assignment brief. Just a minute. So I'm just going to share the assignment brief with you. So this is what you'll be seeing. I mean, the assignment discussion is all around what I've done on here anyway. This will be on Moodle for you. So it identifies the unit, the level 5 and the credits of the assignment. It identifies each task there as well, which is on the assignment discussion as well. What is expected of you to do in each task. So you need to make sure you cover that bit, then each part of it. Then you've got the scenario though in task 2, which identifies the scenario around James and what he needs to do with his wealth once he's died. So these are what you are required to do, and these are the elements, and your answers must be, so each one, analyze features and different types of trusts, apply statutory. So these are the command words: apply, analyze, examine. These are the ones, so you need to be copying and pasting each of these and making sure you are writing under each them. Then if you do the extension activity for task 2, you will be looking at doing both of them elements. So there's 2 elements of the merit criteria, and there's then, if you do the distinction one, there's 3 elements for the distinction. So you need to, if you want to get a distinction, you need to do all the elements of the first part, which is all that, and then all that, and then all that to gain the distinction. If you want to gain the pass, you just do the first part. If you want to gain the merit, you do the pass and the merit ones. So make sure you identify which ones you do it, and it's so clear that it's the merit or distinction ones. Task 3, you need to look at elements of these here. So you've got analyze the impact of illegality on legal presumptions, 2.3. So that's one part, and then right under that. Second part of it is tracing and equity, AC 4.1, and right under that. And then third part is the application of position of defence, and right under that. For a merit, to gain a merit for task 3, you need to do that as a fiduciary duty one to gain the merit, okay? And make it clear that you've done the merit one. For task 4, you are only required to do this one, which is AC 4.3, which is to assess the legal when specific performance or injunction can be granted. And again, you need to refer to the scenario which is given, which is the ATHE scenario in regards to any sort of remedies that are available. So you look at the specific performance or injunction, types of injunction, and maybe identify things like that. These are guidelines for assessors, so they're not really for yourself, but you could refer to them in regards to it. And look at you need to look at case law. So overall, you need to be looking at identifying the law around it, what is expected of you in this assignment. So this is on Moodle, but we've gone through all of it in the assignment discussion slides that I've put on as well. And you need to make sure that if you are aiming for a merit or distinction, you do the extension activities and make sure you cover each element of it and make it clear that it is the extension activities. You need to also make sure that you are not copying and pasting. Again, I reiterate this again and again. And you need, as you are signing a declaration that's saying that work is yours and you've not colluded or there's any sort of plagiarism, and you need to make sure you're referencing your work in text. If you're taking out quotes, reference in text. If you're using case law, make sure you're identifying the cases, okay? If you have any questions, please email learnerwork@ukvarsity.co.uk. We've now finished the assignment discussion for equity and trust unit, and good luck with your completing your assignment, and thank you for attending today's session. Thank you.